Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator Hazel Thompson IE, who is ill. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula May Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. John Heath, whereas Senator Hazel Thompson IE is incapable of performing her duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, John Heath, to be a member of the Senate temporarily with effect from the 9th of March 2021 and continuing during the absence of Senator Hazel Thompson IE by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 9th day of March 2021. Honorable Senators, a senator is required to take the oath.
I, John Heath, having been appointed Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Papers.
Acting Leader of Government Business.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in the names of the Attorney General, the Minister of Public Administration and Digital Transformation, the Minister of Finance, and the Minister of Public Utilities. The annual report of the Equal Opportunity Commission for the year 2015, the stewardship report of the Office of the Procurement Regulator for the period January 2018 to September 2020, the annual report of the Anti-Terrorism Unit for the period 2019 to 2020, the annual report of the Financial Intelligence Unit of Trinidad and Tobago for the period October 1st, 2019 to September 20th, 2020, and the report of the Cabinet Subcommittee appointed to review the operations of the Water and Sewage Authority and to determine a strategy for enabling the authority to achieve its mandate. Thank you, Madam President.
Questions?
Senator Lakshmi Dayal.
To the Minister of Health, given the announcement that only 33,600 vaccines will be available by the end of March 2021 via the COVAX facility, can the Minister indicate when will the majority of the adult population be vaccinated?
Minister of Health.
Thank you very much, Madam President. Madam President, the vaccination of the population has always been based on the principle of those vaccinated first will come into high-risk, high-exposure groups under the COVAX principles. To this end, in Phase 1, NCD patients, which are part of the general adult population, will be vaccinated in Phase 1, the number of vaccines being the limiting factor. In Phase 1, members of the general adult population to be vaccinated will be those in the long-stay homes. In Phase 2, we move on to also those with NCDs, general population again, plus essential workers. And then in Phase 3, the majority of the adult population will be vaccinated, depending again on the number of vaccines that we have. I think we can realize there's a global shortage of vaccines, and we are working assiduously across all platforms to acquire enough vaccines for especially what we call small island developing states, which are being unfairly disadvantaged in the purchase and acquisition of vaccines. So that is how we plan to do it. Phase 1, Phase 2, Phase 3. We start off with limited numbers in Phase 1. NCDs, long-stay homes. We continue with NCDs in Phase 2, and then the majority will be in Phase 3. And I thank you for the question, Honourable Member.
Madam President. Madam President, given that given that your original statement that 120,000 vaccines would be ready by the end of February has not materialized, can you give us an indication as to when the remaining 67,200 that we were guaranteed from the COVAX facility would be delivered, when we can expect them and in what quantities?
Well, one question. So when can you expect them?
When can we expect the remaining
Minister.
67,200, please, Minister?
I welcome the question. When we announced, both Dr. Erica Wheeler and myself of PAHO and myself announced 100 to 120,000, we were at pains to say all things being equal, because we know there's a worldwide scramble for vaccines. And we did say all things being equal. What has happened because of the shortage of vaccines, COVAX has made a decision, and we have accepted this initial advance of 33,600. All things being equal again, I am told by COVAX and PAHO, we could expect the remainder of 77,000 sometime between the end of April, beginning of May, and the 33,000 we are receiving will see us through that period. But again, all things being equal, and we were at pains to say that at the press conferences.
Yes?
Madam President. Minister, given that all things are not equal with COVAX, has the government, or can you give us an update on the government's initiatives to explore other sources of vaccines to help the population reach somewhere closer to what we consider to be herd immunity and what internationally is accepted as being somewhere around 70% of inoculated population?
Minister,
Can you give us an update, please?
Sorry, thank you. So we are exploring initiatives with COVAX, with the African Medicine Council's platform, where we are registered as a purchaser for over 400,000 vaccines across 3 vaccine platforms, AstraZeneca, Pfizer, and Johnson & Johnson. We are also exploring, as we have said, bilateral talks with the government of India, the government of China, the government of Germany, France, and Canada. We are also exploring bilateral talks directly with Johnson & Johnson, Sinopharm, Bharat Biotech out of India. So we are exploring all available options in the context of an absolute global shortage of vaccines, and also where bigger countries where the plants are situated are now embargoing vaccines. Italy has embargoed 400,000 AstraZeneca vaccines bound for Australia, and that is in the news. So in the context of all of that, we are trying very, very hard, and I welcome the opportunity, and I assure colleagues here, the government, all agencies are working very, very hard on this issue. Thank you very much, Madam President.
Questions on notice, questions for oral answer.
Acting Leader of Government Business.
Madam President, there are 3 questions on notice, and the government will answer all 3. Thank you.
The device that just made that sound, can you please leave the chamber and you can come back in 5 minutes? Senator Mark.
Thank you, Madam President. Question number 70 to the Minister of Finance.
Minister of Finance.
Thank you, Madam President. Madam President, this is a complicated matter since the collective agreement in question was not authorized by the ministerial committee established to monitor the conduct of wage and salary negotiations. This committee is now entitled the Human Resource Advisory Committee of Cabinet, which took over from the ministerial committee established under the previous administration. The agreement was not authorized as required by the directions given by the Minister of Finance through the Permanent Secretary of the Ministry of Finance to the Chairman of the National Insurance Board on March the 25th, 2011 under the former administration, and is thus at variance with the provisions of Section 9 of the National Insurance Act, Chapter 3201. The consequences of this agreement are also far-reaching and could result in tremendous expense to taxpayers if used as a precedent. Accordingly, the Minister of Finance is seeking advice on the matter.
Senator Mark.
Madam President, through you to the Minister of Finance. Could the Minister explain to this Senate why was authorization not sought by the parties involved in this collective agreement?
Minister.
Thank you, Madam President. My investigation so far, or let's put it this way, the investigations of the Ministry of Finance so far have indicated, as far as we have been told, that the management of the National Insurance Board did not inform the board of the ministerial directive of March the 25th, 2011. That is our investigation so far. So as far as I'm aware, the management is now being called upon to explain why this letter from the then Minister of Finance was not made known to the board of the National Insurance have at this time.
Senator Mark.
Can I ask, Madam President, through you to the Minister, Honorable Minister, is it a normal practice from your experience that before collective agreements are arrived at between parties at the NIB, that your ministry or the Interministerial Committee on Wages must authorize same? Is it a normal practice and this was a breach of that practice? Can you explain?
Minister.
Madam President, I referred in my answer to Section 9 of the National Insurance Act, Chapter 3201. Section 9 requires the National Insurance Board to comply with directions given by the Minister of Finance. And these directions, given in 2011, have never been rescinded and remain in force.
Senator Mark.
In light of the breach committed by the management in violation of that section referred to, could the minister indicate whether the government would want to consider settling this matter with the relevant players, having regard to the fact that the management is responsible and not the workers in question? Would the government be willing to reconsider its position on this matter?
Minister.
Madam President, those are Senator Mark's words. Those are not my words. All I said was that I have been informed that the management did not bring the ministerial letter and ministerial directive to the attention of the board. That is all I can say at this point in time. This is an active investigation and it is ongoing. And I expect to get a report from the National Insurance Board in due course. With respect to the agreement itself, I have made it clear the agreement has far-reaching consequences for taxpayers. And I can say off the bat that if that agreement, the wage increase that was contemplated by that agreement was implemented in the public sector, it would cost $7 billion. And this is why I am seeking advice at this point in time, and that is all I can say at this point in time.
I ask the Honourable Minister, the period of the collective agreements involved that would have been signed off by the management of the NIB. Can you tell us which periods those collective agreements would have covered, Honourable Minister?
Senator Mark, I won't allow that question. Next question, please. Senator Mark.
Just pull up, Madam. Question number 71 to the Minister of Health.
Minister of Health.
Thank you very much, Madam President, and I thank my colleague for the question. Trinidad and Tobago is a one-country state, and this government's approach to the COVID-19 pandemic and all other health-related matters is and will always be a national response. As such, the measures implemented to reduce the incidence of multi-system inflammatory syndrome, MIS-C, among infants is one for Trinidad and Tobago. As of March 9, 2021, there are no confirmed cases of multi-system inflammatory syndrome, MIS-C, among infants in Tobago. In order to mitigate any risk of occurrence, All public health facilities strictly adhere to the public health regulations, protocols, and guidelines, including 1, the mandatory wearing of masks or face shields and strict adherence to physical distancing, the increased frequency in the sanitation of all public health facilities, close observation and monitoring of all infants who are COVID-19 positive for the development of any signs or symptoms suggestive of MIS-C by the medical team. All patients who are COVID-19 positive in state quarantine facilities in order to eliminate the risk of exposure to infants. The closing of daycare centers and schools with effect from March 14th, 2020, and the closure of the airport to nationals and non-nationals on March 22nd, 2020. Thank you very much.
Senator Mark.
Yeah, Madam President, can the Honorable Minister indicate, seeing this is a national issue, which I agree with, can you share with this House how many infants have contracted or have become victims of this particular MIS-C in Trinidad and Tobago?
Yes, thank you. There are 29 suspected cases, 28 in Trinidad and 1 in Tobago, suspected. In Trinidad, there were 21 confirmed cases. So that is the breakdown, 29 suspected cases, 28 in Trinidad, 1 in Tobago, but on confirmatory testing, we have 21 confirmed cases, all in Trinidad, none in Tobago as of now.
Senator Mark.
Honorable Minister, without telling tales out of school and without breaching confidentiality, can you tell this Honorable Parliament or Senate the 21 confirmed cases that you have outlined of infants contracting this MIS-C? Have they all recovered fully?
I checked this morning with the doctors in both Trinidad and Tobago, and I'm happy to report that all have recovered and we have had no fatalities.
Senator Mark.
Madam President, can the Minister indicate what measures are being promoted by the Ministry of Health to alert the population of steps that ought to be taken to ward off this invasion of this particular disease?
Minister of Health.
So I think I did go through that. The mandatory wearing of masks, I said that, face shields. Specifically for children, Senator Mark, closing of daycare centers. We implemented that in March 14, 2020. Closure of schools. And at our press conferences, we very often bring a pediatrician in the person of Dr. Joanne Paul to speak directly to the population about the issue of MIS-C, both in Trinidad and Tobago. So the public education goes on and the policy measures are still in force with the closure of daycare centers, the closure of primary schools. So those measures are still in force. So a mixture of policy, public education.
Next question, Senator Mark.
Thank you, Madam President. Yeah. Question number 76 to the Minister of National Security.
Acting Leader of Government Business.
Thank you very much, Madam President. Madam President, this matter was investigated. It was verified that the phone call received by the former chairman of the Police Service Commission was associated with the security vetting exercise for candidates who have applied for the position of Deputy Commissioner of Police. Thank you.
Senator Mark.
Madam President, having regard to what the Honourable Minister said, that this call, this mysterious call that came from a woman in that ministry, can the Minister indicate what role, if any, the Ministry of National Security had played, did play, is played in the appointment of 3 Deputy Commissioners of Police? Can you clear the air on that matter? Whether the National Security Ministry...
Just state your question, Senator Mark.
Well, I think I've done
Yes, Minister.
Madam President, I thought for a while my friend was asking a new question, but What I picked up, Madam President, first, Senator Mark refers to the call as being a mysterious call. So the call was not mysterious. I've already said that it was verified that the phone call received from the former chairman of the Police Service Commission was associated with the security vetting exercise for candidates who have applied for the position of Deputy Commissioner of Police. So the call was not a mysterious call. The purpose of the call was not a mystery. It was associated with the security vetting exercise. The relationship to the Deputy Commissioner of Police position is not a mystery because the vetting exercise was for candidates who have applied for the position of Deputy Commissioner of Police. And the recipient of the call is not a mystery because it was the former chairman of the Police Service Commission, Madam President.
Senator Mark.
Madam President, can the Honorable Minister indicate what is security vetting has to do with that mysterious caller asking the chairman, the former chairman of the Police Service Commission for a recommendation? Madam President, I'm simply asking the Honorable Minister to indicate and explain to the Senate the difference between a security vetting and a recommendation, which is reported to have been the request made by this lady calling from the Ministry of National Security.
Senator Mark, I won't allow that question. Next question.
Is the Ministry of National Security involved in the exercise as it relates to the selection of 3 deputy police commissioners? Can the Honourable Minister
The question as you posed it can be, I can now minister.
Madam President, I'm very happy to report that this call, which Senator Mark continues to describe as mysterious, was verified after the investigation. As part of the investigation, it was verified that the phone call received by the former Police Service Commission chairman was not a mysterious call. It was associated with the security vetting exercise, not a mysterious exercise, the exercise for the candidates who have applied for the position of Deputy Commissioner of Police. That is the response, Madam President, to the question posed by Senator Mark.
Senator Mark.
Can I ask the Honourable Minister whether the former chairman of the Police Service Commission has been written to by the Minister of National Security, clearing the air on this matter as you are seeking to do at this time, seeing that he had written him?
Senator Mark, I won't allow that question.
Introduction of bills on the supplemental order paper, the Electronic Payments into and Out of Court Amendment Bill 2021 in the name of the Attorney General, motions relating to the business or sittings of the Senate and moved by a minister.
Acting Leader of Government Business.
Thank you, Madam President. Madam President, having regard to the fact that you recused yourself from participating in the matter of privilege raised and subsequently referred to the Committee of Privileges on Tuesday, March 2nd, 2021, I beg to move, notwithstanding the provisions of Standing Order 82.2, that for the purposes of conducting the committee's work on the said matter only, the President of the Senate, Ms. Christine Kangaloo, be temporarily removed from the committee and temporarily replaced as chairman by Vice President of the Senate, Mr. Nigel De Freitas, and that Mr. Clarence Ramrad be appointed to serve as a member of the committee in lieu of Ms. Christine Kangaloo. Madam President.
Honourable Senators, the question is that notwithstanding the provisions of Standing Order 82.2, that for the purposes of conducting the committee's work on the matter referred on Tuesday, March 2nd, 2021, the President of the Senate, Ms. Christine Kangaloo, be temporarily removed from the Senate and temporarily replaced as chairman by Vice President of the Senate, Mr. Nigel De Freitas, and that Mr. Clarence Rambarat be temporarily appointed to serve as a member of the committee in lieu of Ms. Christine Kangaloo. Those in favour say aye. To be temporarily appointed to serve as a member. No, be temporarily removed from the committee. Thank you very much. So let me just go over the motion again. Honourable Senators, the question is that notwithstanding the provisions of Standing Order 82.2, that for the purposes of conducting the committee's work on the matter referred on Tuesday, March 2nd, 2021, the President of the Senate, Ms. Christine Kangaloo, be temporarily removed from the committee and temporarily be replaced as chairman by Vice President of the Senate, Mr. Nigel De Freitas, and that Mr. Clarence Rambarat be temporarily appointed to serve as a member of the committee in lieu of Ms. Christine Kangaloo. Those in favour say aye. Those against say no. I think the ayes have it.
Public business, government business, bills, second reading.
Attorney General.
Madam President, I beg to move that a bill entitled An Act to Make Provision for the Maintenance of Public Safety and Order through Discouraging Membership of Criminal Gangs and the Suppression of Criminal Gang Activity and for other related matters be now read a second time. Madam President, we stand in March 2021, nearly a full 10 years away from the introduction of anti-gang laws into the body of laws of the Republic of Trinidad and Tobago. That exercise, in fact, began in the year 2010 under then Prime Minister, Mrs. Kamla Persad-Bissessar. In 2010, the introduction of two bills, being companion bills, came to the Parliament to then treat with the scourge of gang activity. The reflections of the advisor to the Honourable Prime Minister then, Mrs. Persad-Bissessar, one Gary Griffith, was that anti-gang law was good law to be introduced because of the suppression factor that it provided. Accordingly, those two bills entered into the Parliament, and a joint select committee was appointed to consider the introduction of anti-gang law with bail restrictions. The anti-gang law and bail restrictions were introduced into the House of Representatives on the 16th of July 2010, and on the 3rd of December 2010, the Joint Select Committee, which was appointed to consider those two pieces of law, comprising members of the House and Senate, then government UNC, then opposition PNM, that JSC having sat with 12 members for 8 meetings, we saw on the 3rd of December 2010, the House and the Senate, proceeding from that date, sitting for 7 sessions in the House and 6 in the Senate, and on the 16th of May 2011, the Anti-Gang Act and the Bail Amendment Act proceeded with full and unanimous support. At that Joint Select Committee, there was unanimity. The Commissioner of Police, then Stephen Williams, acting as he was, addressed the Joint Select Committee, and there was fulsome support for the Anti-Gang and Bail Amendment. On the 16th of May 2011, That ended in the Parliament, and the assent of both laws happened on the 23rd of May 2011, and therefore Acts number 10 of 2011 and 11 of 2011 were born, the Anti-Gang Act and the Bail Amendment Act. The bail amendments were critical as companion law because what they sought to do in relation to gang activity was to restrict bail. A court was put out completely. You shall not get bail for 120 days in the first instance, and if your trial has started, thereafter no bail, unless you cross 1 year and your trial has not gone in the right direction. So the lockdown of bail happened by a complete exclusion of the court. What was interesting is that the laws were proclaimed on the 15th of August 2011, and 6 days later, on the 21st of August 2011, a state of emergency was declared. In that state of emergency, 463 people were arrested under the Anti-Gang Act. As a matter of fact, it turned out 213 were released with no charge. 142 were charged by the Criminal Gang Investigation Unit. And at present, we've had 1 conviction, 33 now at the Magistrates Court, and 40 before the High Court. That law had a sunset clause in it for 5 years. And that law was intended to come to an end in 2016. What's very interesting is that the law was passed with a 3/5 majority, and that 3/5 majority law was because there was going to be an intrusion of Section 4A of the Constitution, the right to liberty effectively, 4B, the protection of law, 5.2a, the detention provisions set out in the Constitution, 5.2e, the due process provisions, because in the anti-gang law in 2011, what happened was the courts were told to come into effect only after 72 hours had passed, and then you had a further option for detention, and the courts were told, look, you can have no part in releasing these people, they are under investigation. So the 3/5 majority requirement happened under detention. This bill we lay here today without a 3/5 majority, and I'll explain that. Let me flag immediately to honorable members that there is a critical amendment to be had to Section 15.3. Unfortunately, the bill that came before us today did not have the correct provision of consent for entry into other premises and then warrant after. So, to my friends in the opposition, don't get too excited yet. We spotted that, unfortunately, in the rush to lay the bill, the wrong version was laid in respect of that clause. And there are a few other amendments that we'll ask you to consider. So, Madam Speaker, Madam President, in Act number 10 of 2011, the Anti-Gang Act, permit me to reflect upon the preamble, because we have a much shorter preamble in this bill. But the preamble in the 2011 Act is critical, because it featured as well in the 2017 and 2018 versions of the Anti-Gang Act. Whereas the Constitution of Trinidad and Tobago effectively recognizes and protects fundamental human rights and freedoms such as the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process of law. And whereas the Constitution also recognizes the existence of the right of the individual to equality before the law and to protection of the law. And whereas the Constitution places a duty on the state to protect, promote, and fulfill the above-mentioned fundamental rights and freedoms, and whereas there has been a rapid growth of criminal gang activity within the Republic of Trinidad and Tobago, and whereas criminal gang activity infringes on the rights and freedoms of individuals as enshrined under the Constitution, and whereas it is the right of every person to be protected from fear, intimidation, and physical harm caused by the criminal activity of violent gangs, and whereas criminal gang activity presents a danger to public order and safety and to economic stability, and has the potential to inflict social damages. Let those words marinate for a moment. And let us reflect upon the state of Trinidad and Tobago 10 years later, as there are marches up and down Trinidad and Tobago, quite commendably, where our citizens are crying for the right of protection. There was an interesting placard that said, "Walk free, not brave. Walk free, not brave." And whereas we are now regaled by the story, anecdotally in the papers, of gangs kidnapping our young ladies, a driver in association with a rapist allegedly kidnapping our young ladies, extorting money via someone else, receiving stolen goods in a coordinated attempt that has now shown us it's not just one, it's several. So that's Trinidad and Tobago 10 years later from 2011. That is a relevance. Today, we seek to reintroduce the anti-gang laws with no sunset clause, no 3/5 majority, because we attenuate the rights, and I'm flagging that an amendment is critical to section 15.3 of the bill to make sure that we don't trip the right of property in respect of police entering without warrant. That has to be amended. But in Trinidad and Tobago, let's look at the effect of the law which we now seek to reintroduce. We know the history of the law. The history of the law is that it was born out of a Joint Select Committee in 2010. It came into 2011. We know that the expiry of the anti-gang laws came up in 2016. We know that the government came forward, I came forward in 2016 with the miscellaneous provisions, anti-gang and bail amendment, Bill 2016, and I asked the House of Representatives on the 17th of June 2016, 9 months after the election, for an extension of the following laws. The Bail Amendment Act, number 10 of 2011, that's the companion to the anti-gang. Number 17 of 2008. Number 10 of 2011, that's the Anti-Gang Act. The Bail Amendments, Act number 11 of 2011, 1 of 2014, 7 of 2015, far-reaching bail companions, no bail for possession of a firearm, no bail for anti-gang law, no bail for child abuse in the terms of raping a child and sexual offenses against a child, no bail for kidnapping for ransom. Unfortunately, on July 1st, 2016, the opposition refused to support the extension of time. We were simply asking for a 2-year extension. And the opposition simply said they will not support the law. The Anti-Gang Act died, and all of the bail amendments that we had advanced from 1994 straight up to 2015, one strike, firearm, no bail, all died, except for the 1994 law as amended by the Act number 19 of 2005. So kidnapping, no bail, went out the door. Serious offenses against children, trafficking in persons, charge matters, all died. Because the opposition's position was we will not extend the law. The anti-gang bill number 20 of 2017 came forward. We wrote to the DPP, the Commissioner of Police, the Law Association. We held a meeting with the opposition on the 18th of July 2017. We had correspondence with the leader of the opposition, 4th of August 2017, 17th of August 2017, 28th of September 2017. We laid that bill on the 1st of December 2017. On the 6th of December 2017, we deleted the offense of sedition from the schedule. We said that we would go for 18 months as the condition being dealt with. That was what the opposition had asked for. We asked instead for a slightly longer period, and the opposition said no. The Anti-Gang Act of 2017 died. From the Act of 2017, we went into the dance for 2018. In 2018, we came back with a new bill. There was mounting public pressure. The Commissioner of Police was begging for the law. The society was begging for the law. We sought to waive the standing orders with the cooperation of the Honorable Leader of the Opposition, and we brought forward the 2018 law. And the 2018 law, we did some surgery. Very importantly, we added in white-collar offenses into gang activity. A huge difference. The white-collar offenses in the schedule. Offenses under the Anti-Terrorism Act. Offenses under the Proceeds of Crime Act. Offenses under the Prevention of Corruption Act. Trafficking in Persons Act. Misbehavior in public office. Offenses under the Gambling and Betting Act. Why? Because we were following the money. And we said if we can't catch you for murder in gang activity, or kidnapping in gang activity, we'll catch you for follow the money. The Anti-Gang Act in 2018 came alive. There was a sunset clause, hard fought for 30 months. In November last year, 2020, we came to the Parliament to ask for an amendment to Section 20 of that Act, simply to ensure the extension of the Anti-Gang Act. One effective clause, we said, with respect to Section 20 of the Act, we said this Act is amended by repealing 20, meaning remove the sunset clause. Unfortunately, the opposition took the position that that law could not be supported. The honourable members felt that there was no position of success under the anti-gang law, and therefore we were compelled to watch that law die again. So we've had a tumultuous history with anti-gang law because effectively the laws as presented required a 3/5 majority, and therefore we had to go back to the drawing board to consider how we could make proportionate laws that did not offend the constitutional requirements for 3/5 majority by adjusting the laws so that we are not within the disproportionate realm. Let's deal with the statistics of anti-gang law. Let's deal with what the Commissioner of Police has said. The Commissioner of Police wrote to me on the 15th of October 2020. The Commissioner of Police has been in the newspapers. The Commissioner of Police has been the one operationalizing anti-gang units. The Commissioner of Police said that he inherited a CGIU, a Criminal Gang Investigation Unit, in 2016. In 2017, that CGIU was combined with the OCNFB, another division of the TTPS, the Organized Crime, Narcotics and Firearms Bureau, joined with the Criminal Gang Investigation Unit, and they comprise the OCIU, that unit which deals with criminal investigations for gangs, Organized Crime Investigation Unit. In 2018, the Commissioner of Police took the opportunity to decentralize gang management, creating a center post, but with individual units across all of the divisions. And in 2020, the Commissioner of Police dealt with the Criminal Investigation Bureau. But the information that comes from the Commissioner of Police is quite important. In 2018, the Commissioner reported that there were 211 gang members, comprising some 2,400 gang members. And in 2020, the Commissioner of Police was able to demonstrate a drop from 211 gangs to 129. That's a 39% drop in gangs. In respect of the number of gang members, the number dropped from the 2018 figure of 2,400 to 1,014. That's a 58% drop in gang membership. The Commissioner reports that gangs dissolve themselves because of the constant police suppression activities. That's why I read the preamble, to suppress and deter. The Commissioner of Police informs that in 2018, with respect to murders attributed to gangs, 22 gang-related murders were solved with 28 arrests. In 2019, 13 gang-related murders were solved with 10 arrests. In 2020, 5 were solved with 13 arrests. The Commissioner goes further to describe even more successes. that gang leaders have been charged and are before the courts. Gangs have been disrupted. But let's take a step back. The Commissioner of Police just reported to the country the lowest statistics for serious crimes in 20 years. Let me repeat that. The lowest statistics for crime, serious crime, in 20 years without the use of a state of emergency. Now, I've heard it said, members of the opposition included, that COVID is to be thanked for that. But I just stick a pin for a moment to say that in every other country around the world with lockdowns, which we didn't have, because we did not use the state of emergency, in every other country around the world, the numbers went in the opposite direction. Crime went up. But in Trinidad and Tobago, we now have, because of innovative thinking, people rushing to check their tint, checking demerit points every 5 minutes, slowing down for cameras. The lowest number of road traffic deaths in 20 years. 65 years. The lowest number of traffic deaths in 65 years. So here's what the Commissioner of Police tells us. As I ask, what time is full time, Madam Speaker, Madam President?
You finish at 11:47.
Much obliged. Dismantling of gangs in 2020. G-Shine Gang, responsible for murders in the Northeastern Division, dismantled. Princestown Gang, responsible for quadruple murder in the Southern Division, dismantled. Gang-related murders dropping across the year. By way of comparison, the Commissioner reported that in the year prior to 2020, there were 11 gang-related murders in the month of July, and that dropped to 1. 9 in the month of August, that dropped to 3. 9 in the month of May, that dropped to 2. 9 in the month of April, that dropped to 3. Tobago gangs, 5 murders were solved as a result of this dismantling, linked to the Port of Spain gang division. 94 million in transnational gangs. 8 persons arrested, 2 persons charged to date. Western Division gang, 5 murders solved as a result of this dismantling. They were also linked to Port of Spain gang. Murder in Belmont solved through anti-gang work. A particular name which I won't mention in relation to a gang. 2 gang members arrested and charged for supporting a gang. 2 gang members arrested and supported as being gang leaders. 3 of the 4 gang members arrested and charged for possession of 16.1 kilograms marijuana found and seized. And the data goes on and on. Stick a pin. Today we laid the report of the Financial Intelligence Unit with nearly $30 billion in suspicious activity reported. Not by mistake, because of the demonetization of cash, because of the improvements in the law. In fact, it is a direct result of the laws that we put in the follow the money and transparency provisions, which is why I constantly state I don't need Transparency International to tell me anything. I can deal with the FIU and the ratings of international agencies in relation to Trinidad and Tobago's performance, not anecdotal data that nobody bothers to check. The transparency says we're going in the right direction because the FIU's compliance relative to this bill fits in the schedule of this bill, which is the follow the money. The same way that a particular murder and savagery to a young lady in this country was found by way of a withdrawal of cash from her bank account into the hands of someone else, linked to a taxi driver, linked to PH, linked to the murderer. Follow the money. So we have on test here today anti-gang law. What does this bill say? Why is this bill proportionate? Why should it be supported without a 3/5 majority? What are the protections? Why is it different from the 2018 bill? Why should honorable members even contemplate this bill? Let's go to the law. We propose that the Anti-Gang Act come in. We have kept the wording of this law almost exactly the same as the 2018 law. Save, we have modified in clauses 15, 16, and 17 what would have concerned the 3/5 majority requirement. We've deleted the sunset clause, which would have been the old Section 20. We've caused some consequential amendments to the Proceeds of Crime Act because of the manner in which we treat with forfeiture of property. And we have sought further fulminations, which we'd like to put on the floor. I'd like to put right now. The intention was to bring the law as close to what it was so that honorable members wouldn't be too frightened by it. Explain the 3/5 majority issues and why we don't need it, but to throw out some corn for consumption. Do we want to amend the summary offenses to hybrid offenses? Because there's a risk of running in the statutory clock. There's a 6-month period for a summary offense. If you cross the 6 months, you're out of town. Or because there's a combination of indictable and summary, and therefore the trial, as we move to abolish preliminary inquiries, will fall into jeopardy. There are a few things I'd like to throw onto the floor, because we'd like on this floor to consider wider amendments, as we hear from honorable members as well. So we have no judicial criticism of the anti-gang law. I refer to Mr. Justice of Appeal Nolan Barrow in the case that he dealt with. I won't deal with the case because it's on appeal at the Privy Council, not for gang-related matters, but in relation to quantum and sum for damages that were awarded. But suffice it to say that Mr. Justice of Appeal Nolan Barrow, in describing the one case that considered the deeper ramifications of the anti-gang law, said, whilst it is no slam dunk, to use the judge's words, it's good and useful law. We have in the legislation as well affidavits to be referred to in litigation, in particular, very powerful affidavit of then Commissioner of Police Stephen Williams. The courts have taken judicial notice. We have 40-odd matters in the High Court, 33 in the Magistrates' Court. We have some 35 charges at present for gang leaders and other positions. The law is working. Those matters continue because the offense existed at the time, and therefore they'll continue to be prosecuted. So when we get to the definitions section at Clause 3, we've kept the same definitions. I'd like to suggest on the floor today that we cause an amendment to the law enforcement authority. Law enforcement authority means add the SRPs, add the municipal police, and add the PCA, because it becomes relevant when you're looking at retaliatory action. And we have just amended the PCA law to allow the PCA to go on hunt for white-collar crimes against police officers who may be in gang membership. And therefore, I think it is an appropriate position to throw that out now. I'd like to say that we also look at Clause 4. It's the same as existed at Section 5 of the 2018 Act. When we get to offenses, Section 5 is the same as Clause 5 is the same as Section 6 was in the 2018 Act. I do propose that gang membership, gang leader, membership in a gang, professes to be a gang member. I do propose now for consideration that we ought to consider an amendment to subsection 3 of this clause, specifically to make it hybrid for being a gang member or performance of an act as a condition of membership or professes to be a gang leader, etc. Why? Because there's a collision between the 6-month limitation period and no limitation on the indictable side, and there are often multiple charges offered, and therefore we ought to allow the prosecution and the DPP the ability to harmonize the law, harmonize the charges, harmonize the prosecution. Madam Speaker, Madam President, when we get to Clause 6, which was Section 7, coercing and enticing to be a gang leader or gang member is the same offense. When we look to retaliatory action, this was a novel thing introduced into the 2018 law, where we said, let us protect the members of intelligence agencies and law enforcement from retaliatory action. Let's criminalize retaliatory action, because that is what was happening. Prisoners were being murdered. But stick a pin. We have now added in the bugging of prisons. We are now in a different Interception of Communication Act. We balance that act. There's more intelligence coming from one of the most difficult environments, which is the prisons, where prisoners are being given access, despite best efforts, to telephones and to communication. And therefore, we have added in the bugging of prisons, and I can tell you that that is flowing very well in accordance with the Bailey principles. Let us get to person knowingly counseling gangs. Clause 8 was Section 9 of the 2018 law. Let us get to preventing gang leader or gang member from leaving a gang. That's Section 10 of the old law, 2018 law. It's Clause 9. Clause 10 was Section 11, possession of bulletproof vest, etc. All of these laws, no criticism, charges offered, cases proceeding. The submission is to leave it as it is. When we get to 11, harboring a gang member, it's the same as the old Section 12. At Clause 12, concealing a gang leader or gang member, I genuinely believe that Clause 12 can be open to creation of hybrid offenses, again allowing the summary and indictable split for the purposes of harmonizing prosecution and charges. And I say the same thing in respect of Clause 13, which is recruiting a gang member. We go to Clause 14, which is tipping off. It stands exactly as it was in the old law. That would have been Section 15 of the 2018 law. Let's get to Part 3. This is where the 3/5 issue arises. Police powers of officers. 15.1. A police officer may arrest without warrant a person whom he has reasonable cause to believe is a gang leader or gang member, or who he has reasonable cause to believe has committed an offense under this act. I draw from the existing law, the Criminal Law Act, Chapter 1004. I deal with Section 3 of that particular act, arrest without warrant. We're safe. No 3/5 required. I go to 15.2. A magistrate may issue a warrant to a police officer to enter and search a dwelling house. It's the same as the old law. That's warrant. Therefore, we are safe with due process. No 3/5 required. Subsection 3. This is where we had the problem with the publication of the bill. Subsection 3 should have been followed by a subsection 4. Subsection 3 should have provided that a police officer may enter without a warrant only on consent, just like we do in the Financial Intelligence Unit Act. My learned colleague, Senator Lakshmi Dayal, would be well aware of that provision. And if there is no consent, there must be a mandatory obligation to obtain a warrant. Therefore, taking us into the realm of due process, this clause will be proposed to be amended with certainty. Detention of persons. The Constitution provides that you should not be subjected to arbitrary detention. Let me put the principle of law. Section 2 of the Constitution says that the Constitution is the supreme law of the Republic of Trinidad and Tobago. Nothing that we do in this bill today takes away the right of habeas corpus. You are entitled, as Senators Welch and Senators Heath will both know, to approach a court immediately to consider habeas corpus. We preserve the supreme law, the Constitution, the right to challenge your detention by way of habeas corpus. Nothing interrupts that. Secondary to that, we propose in Clause 16 that instead of the detention for 72 hours, which is what the old Section 17 had, we've gone to what the common law or the standard practice of Trinidad and Tobago says you can be detained for investigations, and that's 48 hours. Stick a pin, Baroness Hale, Surat, it's the easiest case to reference. It's from the Privy Council. You can be fancy all you want and refer to Francis and Northern Construction and this one and that one. Irrelevant. Is the law proportionate insofar as it is a feature of law that is known to your democracy in the state that you're in? And the answer to that is quite simply yes. Clause 16, we propose 48 hours for detention. Bear in mind, nothing stops your habeas corpus application in law, in the constitutional sense. We then go on to say that if you want to have the further detention, which the old law provided as well, the old law provided 72 hours as opposed to 48 hours. We have said if you want a further detention, ask a court to have the privilege to detain someone. Not the police, not the executive, quote unquote, the judiciary in adherence to the principle of separation of powers. There can be nothing more by way of due process in the sense of Sections 5 of the Constitution and its subsets, and also in the respect of Section 4 of the Constitution. And we say if you want to detain somebody, ask the court for permission to do that. I'd ask you to note that we're not asking for a magistrate to do that. We're asking for a judge to do that. Not a master, but a judge. So that we're going for a higher level of scrutiny, which is what the European Court of Human Rights, which is what the Supreme Court in the UK, which is what the Canadian and US courts tell you. Go for a higher level of judicial scrutiny in the exercise of due process. Let's get to Part 4, forfeiture of property, because this is different, Clause 17. In the old route, we had provisions of forfeiture, standard, because it's forfeiture on conviction. And we had a process of notification, etc. But we used a process which was outside of a very good process that we have, a robust and transparent process set out in the Proceeds of Crime Act. So we took the opportunity, as we've been harmonizing our laws, in this version of the law, to say, if you're going to forfeit property, look at Clause 17(1), where a person is convicted of an offense, that is, there's due process. The court may, that observes the separation of powers, not shall, it may, order that any property used for or in connection with or obtained as a result of or in connection with the commission of the offense be forfeited to the state in accordance with the Proceeds of Crime Act. Why have we gone for the Proceeds of Crime Act? Because we took the civil asset forfeiture law, Explain Your Wealth, we harmonized that with Proceeds of Crime. We now in the most robust side of the equation on the anti-gang law, because we want to separate gang members from their property. We want to take the proceeds of crime away from the gang activity. We want to have them sweating that they are at risk of losing their assets. And what we say here is harmonize that law with the Proceeds of Crime Act so you can flow into the seized asset fund. Why do you want to flow into the seized asset fund? Established, in fact, by this government, because we want to take the proceeds of crime and put it to good use in the society, to education, to turning away from crime, to supporting alternate remedies, to making sure that we tackle the concept of recidivism. The proceeds of crime should be used positively. And therefore, we think it appropriate, as we are following the money, and Madam President, permit me to say now, without any interruption of sub judice, we have landmark cases before the courts right now on Explain Your Wealth. Let me repeat that. We have landmark cases now before the courts on Explain Your Wealth. And when those judgments come to the fore, Trinidad and Tobago will be in a different zone. The same way, people are rushing to check their tint, slowing down on the roads where there is a consequence in law. The new society must be envisioned. That ties into the transparency in the company's registry, the transparency in the land registry, the beneficial ownership aspects. That translates into the transparency in cash, the financial obligations regulations, the FIU, the mutual assistance in crime matters, the amendments to the Income Tax Act, PCA Act, Securities Act. Come on, folks, connect the dots. There is a different matrix of laws today. Are people satisfied that that is working for them? No, because the system is now churning and the product is now coming out. We're now seeing matters that were waiting 18 years for trial being over in 15 minutes. We're now seeing visual evidence at work. We're now in the position where we stop moving 15,000 prisoners every 3 months and do it in a virtual setting, saving $25 million a year. This is no Trinidad and Tobago of yesteryear or of 2015. This is a new Trinidad and Tobago. And yes, it needs to work faster, but I have faith that we're on the right track. So the proceeds of crime is harmonized. The schedule to this law provides for the reference to proceeds of crime. In particular, we begin at items 27 through inclusive to 32. And that's important. Misbehavior in public office is a requirement if we're going to treat with corruption in the public service and amongst more senior people. Amongst more senior people. You see, I am a person that believes that the US exercise in prosecuting Al Capone for tax evasion was a very powerful tool in the US context. And as we go digital, thanks to my colleague Alison West and my colleague Senator Hasselbachus, as we go digital, as we have records in place, Trinidad becomes a different place, honorable senators. Miscellaneous, the minister with responsibility for national security may, by order, subject to negative resolution, amend the second schedule. That's the standard law. We've had that in the 2018 law. We're now adding that the minister may make regulations, because with their move to the proceeds of crime harmonization, we think it appropriate to have regulations as companion to this law. I will propose an amendment to clause 19 to allow for an exception to section 63 of the Interpretation Act, even though we amended section 63 of the Interpretation Act last year to say that the breach will be at $100,000, etc. I believe that we need to go further to $250,000 and 7 years. So I'll propose an amendment to clause 19 when we come to it. Clause 20 treats with the Proceeds of Crime Act. Because we are harmonizing the forfeiture of property with the Proceeds of Crime Act, a consequential amendment is necessary. So, Madam President, do we need anti-gang laws? That's for us to decide. Have they been working? The Commissioner of Police says they have. Sure.
Through the Honorable President, would you be circulating your amendments as soon as you're through so we can have sight of them?
I hadn't proposed to circulate those amendments yet because I've come to the Senate to listen to the contributions of all honorable members. Because it is appropriate that this Parliament considers law in the round. We don't come to pass law for ourselves.
Attorney General, you have 5 minutes.
Thank you very much, Madam President. We want to hear the submissions of learned colleagues. We've been through the dance with the opposition 2016, 2017, 2017, 2018, 2020. We know how that story ends. We had to go back to the drawing board. Back to the drawing board means watering down some of the provisions. We would like to have longer detention periods because the police tell us that that's what works. Longer detention periods work because when you are in the realm of interception of communication, you retrieve devices, you have to crack the devices. They may not happen in 48 hours or 72 hours. You may have multiple persons. We want to attend to the issue of prisoners and detention of prisoners. It's an issue that we have aside from this, and we'll come back to the Parliament if we can on that. So we would want to have longer detention periods, but unfortunately, that will require a 3/5 majority. And because the House of Representatives is not populated by the government with a special majority, we have to abandon a few better protections for Trinidad and Tobago in terms of the fight against crime, because we must adjust ourselves to accommodate the opposition's point of view. And that point of view, plainly stated, is that they will not support. They saw no position of support for the 2020 extension. I can't imagine it'll be different today because the law is the same. I expect to hear the song and dance in relation to constitutionality, etc. I'm prepared to risk that on the advice that has stood the test of time in relation to due process and proportionality coming from the Privy Council's decision. It's no risk in my view. It's something which is defendable. We can defend it within the confines of the Constitution and the Privy Council dicta, which is supreme law in this country. We've dressed back detention. We will amend Section 15.3. I apologize for the error in that circulated draft. There is no circumstance where you can enter somebody's property without consent. You must have a warrant. If it were otherwise, you will require a 3/5 majority. The old law, the 2018 law, provided you could enter any premises without a warrant. That was very powerful. That is the fight against crime. That's what we want. But we don't have the opposition support. So, honorable members, Madam President, I look forward to the contributions of my colleagues in this House as we fight to demonstrate to the people of Trinidad and Tobago that we are listening, all of us, to their exhortations, to their desire for a better Trinidad and Tobago, to their desire to walk free, not brave. To walk free, not brave. I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Make Provision for the Maintenance of Public Safety and Order through Discouraging Membership of Criminal Gangs and the Suppression of Criminal Gang Activity and for other related matters be now read a second time. Senator Lakshmi Dayal.
Thank you, Madam President. Madam President, the Attorney General never ceases to disappoint. He never disappoints when he talks about Surat. I look forward to it. I always wait for the Surat. And I waited with eager anticipation here today to hear the Surat argument. Madam President, the Attorney General has also made mention that he has been through this song and dance with the opposition. But having been through the song and dance with the opposition, Madam President, I would have expected to hear a new tune today. Since he wants a new dance and a new song, but there's no new tune being played by the government here today. What the Attorney General has brought before us today, Madam President, is the same arguments that we have heard and the same arguments that we had issues with when the opposition did not vote to support the extension of the 2018 Anti-Gang Act. And that is empty statistics. Madam President, you cannot pull statistics out of thin air and expect the opposition or the population, by extension, to accept that they are relevant. Madam President, so let me just go back a little bit into some history. The Attorney General has made much about the fact that the suite of legislation, anti-gang and bail, were meant to work in tandem together. I accept that. That is true. The People's Partnership Government brought those pieces of legislation together to work together to deal with the scourge of crime. Madam President, when in the 2018 law came to an effective end and the sunset clause, they asked in the House that it be extended, there was no support for one simple reason. The government was unable to demonstrate effectiveness of this legislation. So when you stand in the Parliament here today and again say that, for example, on the 15th of October 2020, the Commissioner of Police said that 211 gangs were in existence before and 2,400 gang members existed, and that went down from 211 to 129 and 2,400 to 1014. Madam President, where did they go? Did the gangs go before the court with a winding up petition? Did the gang members migrate? They handed in their membership card? Did they fall off a chair in the police station? What happened to these people? These statistics, which I have not seen it circulated to members of this Honorable House. I have not seen the source of this data to date. We had this debate in last year, November, where the opposition raised these concerns. The Attorney General has come again, and apart from Surat, he has brought what has become very familiar again to us when we deal with matters that are deal with the criminal justice system and criminal laws and legislation when to tackle crime. And it is the rhetoric. Madam President, how could a responsible Attorney General stand in the Parliament today and say that the death of a young girl was caused by a gang and people working together? That is a matter before the court. It is a matter where people are still innocent until proven guilty, and it goes to show how the government will capitalize on emotions running high amongst the population to have their way. So they have brought a piece of legislation to the Parliament today, which they intend to pass with or without our support, to say, and I take serious issue with that because, yes, I will bring the constitutionality issues, but they have come here to say that they will do it. And, it's interesting that when the bill lapsed in 2020, the opposition was accused of dog whistling. Well, I've heard a lot of dog whistling to the population here today, Madam President, when we are basically saying that without this bill, crimes such as the ones that are currently affecting the population on such an emotional level will continue. Madam President, it is irresponsible. It is irresponsible to speak about matters which are before the court, where persons died in police custody and there's an ongoing investigation into that, without being able to prove their innocence or their guilt, and who had never been charged. But that is the rhetoric that we are faced with here today. We are not faced with solid arguments to say that this law has been proven effective. We are not faced with documentary evidence that show surveys and academic studies and so on that deal with the reduction in the membership of gangs. We have the Commissioner of Police say so. What is the basis of saying so? Well, I realize now that this is the answer to everything. Well, it's based on intelligence, because they have CGIU, OCNFB, OCN something else, B, SIU. I think 3/4 of the problem is we have too many units working together. But up to now, I have not heard anyone establish how. And you cannot say it is intelligence and we cannot tell you. That is a very empty and meaningless response to the questions being posed by a responsible opposition to ask, where is the evidence that this law is working? If you want to have laws in place that are infringing upon the guaranteed rights and freedoms of individuals, you must bring better evidence than that to show that the legislation is effective and that this is working. We are committed to supporting good law. We have always maintained that, and we maintain that we will support good law. Madam President, in respect of the bill itself that is before us here today, the Attorney General has made mention of the fact that this is, that the word suppression is used a lot by the Commissioner of Police when he talks about the use of the legislation. And Madam President, again, what is suppression? Is this meant to just be a holding law? Because the statistics that we were able to obtain talks about a large number of arrests being made, but very few charges. You see, when you come before the court, the Parliament, or even and in the public arena, and you speak about the number of arrests being made, the persons arrested for offences under the Anti-Gang Act, I have it in front of me here, save and except the 2011, as the Attorney General spoke about, when we had the state of emergency, where I believe 208 persons were arrested for being members of a gang, and in total, we had 222 persons arrested in 2011. The grand total up to 2020 as provided, and this is provided by the Crime and Problem Analysis branch of the TTPS, the grand total we had was something like 291 persons arrested. How many of these 291 persons have been charged with offenses under the anti-gang law alone? And I say alone because I heard the Attorney General make mention of one conviction. Well, that's very interesting, because in a public hearing that deals with gang-related violence and so on, the question was posed quite recently about convictions under the Anti-Gang Act. And it is my information, and I will be I'm subject to correction if the Attorney General can confirm, but has anyone actually been convicted of a crime created by this law that was in effect from 2018 to 2020 for 30 months? And I believe the answer is no. Because you see, and again, we get back into the rhetoric. Last year, when the act wasn't extended, victory for gangsters was the story being peddled. Charge criminals to walk free month end. And Madam President, this was based on statements coming from persons within the government. And yet the Director of Public Prosecutions, and I'm happy that the Attorney General said here today that the cases are continuing, to demonstrate that this was just empty rhetoric, meant to put pressure on the opposition last year, the Director of Public Prosecutions had to come out and say, well, no, the charges that were brought under the old law would continue. But the fact of the matter is that not a single person to date has been convicted of an offense under the Anti-Gang Act by itself. And that is important for this reason. Every type of activity contemplated by this piece of legislation as gang-related activity is already an offense under the law. And the majority of the time, the persons who are arrested and ultimately charged, they may also be charged with, if there's evidence that they have become members of that they are working in tandem as members of a gang, whatever that evidence may be, they are also charged with being gang leaders or members of a gang and so on. But there are existing laws that you can charge them under. And the DPP last year, and this is from the November the 22nd story carried in the Newsday, he said he noted, and he was being questioned about the lapse of the 2018 law. He said he noted that police can continue to investigate gang offenders for murder, kidnapping, and a host of other serious crimes under existing legislation. This is the person, the subject matter expert, the person with the constitutionally vested power to tell the police who to charge and who not to charge. And he has agreed that the existing law provides that you can arrest persons for all of these things. So this is why I refer to this anti-gang bill as a holding bill. Because what you are really saying here is that I want to give the police the power to detain people. I want to give the police the power to lock up people for up to 14 days. And I understand why that may be seen as something that is desirable in circumstances where, for example, you have witnesses being threatened and so on. But, Madam President, has it been effective? Have we seen a reduction in crime? The Attorney General quoted statistics to say that about the number of murders that were deemed to be gang-related that were solved. But the statistics from the police also show that in 2017, you had 495 reported murders and the detection rate was 89. So even though you're saying that some of the detected ones are gang-related, well, what about the others? What about the others? Are they gang-related and you are unable to solve them, or do you not know? What happened in 2018 when we passed the Anti-Gang Act with opposition support? Murders rose to 517 with a detection rate of 83. So murders going up and detection is going down. 2019, reported murders, 536, and a detection rate of 42, Madam President, 42. This is when the anti-gang law was in effect. So to say that we have given the police powers under anti-gang legislation, the Holding Act, all the powers to hold and detain persons, and it will result in an impact on the situation that we face in the country in crime, it is simply not supported by the statistics. It is simply not, Madam President. We had a similar situation with shootings. Shootings in 2018, according to CAPA, it's available online, 711 reported in 2018, 248 detection. 2019, with the law in effect, the anti-gang law, shootings went down to 607, but the detection rate fell to 146. So how is the law being used and how is it? And Madam President, this is not only the opposition saying so. I want to quote from, again, last year when the opposition did not support the extension of the bill. The Sunday Express editorial of November the 21st says very clearly here. Now I know the lowest crime rate in 2020 in 20 years is a real feather in the cap of all the interested parties that they wish to promote. But it's not just the opposition that has an issue with this and takes issue. In this editorial itself, it talked about the fact that, and let me just quote a little bit from it, first introduced by the partnership government in 2011 and later resurrected by the PNM administration in 2018, anti-gang legislation gives the police service extraordinary powers to combat the scourge of gangs. The public agreed to temporarily surrender several basic constitutional rights to allow the police to prosecute and convict gangsters. Now, after that, it comes down to say, and this is the editorial, this is not the opposition, this is not the UNC, this is not me. It was simply not enough to argue, as Attorney General Faris Al-Rawi did, that gang activity had declined over the past 2 years with a reduction in the number of gangs from 2011 to 129 and in gang memberships from 2,400 to 1,014. The exact same thing that we have heard here this morning, Madam President. Without context and details, these are empty statistics. This is not the UNC, this is not me, this is not the opposition, this is the Express. Further, for the AG to cite arrests in gang-related murders as evidence of the act's success means equally nothing in the context of existing laws against murder. So even the Express understands that you have an existing law that allows you to charge someone for murder, whether they're in a gang or not. The comment by Police Commissioner that the anti-gang 2018 had been a major deterrent in reducing murders by over 115 this year compared to the same period last year is facile. The more likely cause is the COVID-19 regime of shutdowns and closed borders which have cut off the country from international drug trafficking and organized crime networks to which Trinity gangs are connected. So, you know, to say that it's only the opposition is arguing that COVID had a reduction in crime, empty, Madam President. We have heard this coming from many persons in the country. The Attorney General says we were never in lockdown. Well, I beg to differ. We are still in a state of semi-lockdown, Madam President. We still have restrictions on what we can do on gathering. It may not be enforced the way it ought to be enforced. It may be enforced very selectively. It may be I find that the enforcement is quite selective in nature. But the fact is we still have restrictions on the amount of persons that could gather in a particular place. So how do you justify those things in the context of arguing that we have seen a reduction in crime and that this law has been effective? Now, Madam President, I was happy to hear that the Attorney General is open to debating this on what we want to make as a good law. As I said, we always support good law, but let us look at some of the provisions of this bill. Let us get to the constitutional infringements. It appears that the Attorney General has read my mind with respect to Clause 5 and his summary conviction. I did have an issue with summary conviction for the offenses created by Clause 5 and the imprisonment for on a first conviction, imprisonment for 10 years. So I'm happy if he is making that amendment, and I would support an amendment to make the offenses under Clause 5(3) to be triable either way offenses, because I do believe that a person should have the opportunity to go before a jury in order to prove their innocence if they are accused of performing, for example, performing an act as a condition for gang membership. Madam President, I want to take us to Clause 10. Now, this is a clause that has existed before. It deals with the possession of a bulletproof vest, firearm, ammunition, or a prohibited weapon. Prohibited weapons, of course, defined as under the Firearms Act. But Madam President, Clause 10(1)(b) that says it also creates an offense for a person who has in his possession any of these items who ought reasonably to know would be used in the commission of gang-related activity, commits an offense and is liable on conviction to indictment for imprisonment for 15 years. Now, the clause goes on to state that it should be a defense for a person if he is charged under that section where in his possession he ought reasonably to have known that it would be used. For the person to prove that he did not know or could not reasonably have known that the item, I'll just say the item, would be used for the commission of gang-related activity. This is tantamount to something like a reversal of proof. It's not a strict liability offense because the prosecution is still required to prove that ought reasonably to know, so there is still that mental element contained in this offense. But I find the drafting of the section a bit clumsy because I would not want to be the tribunal who would have to adjudicate on this matter of who ought reasonably to have known that something would be used, as well as I would not want to adjudicate on whether or not someone has proven in his defense that he could not, that he did not or could not have reasonably known. So I would like the Attorney General to examine Clause 10 very closely. I know it is from the existing 2018 law, but in the context of what you are doing and passing a simple majority bill here today, Madam President, I feel that this section creates room for persons who are caught in a situation to be faced with very serious charges, which carry very serious consequences. So I would ask the Attorney General to consider looking at Clause 10, tidying it up a bit, and let us see where we go from there. If it is that the intention is to create something like a strict liability offense, well then do that. But of course you would, I believe, require a constitutional majority to do so. For the purposes of persons who want to appreciate what this is about, there's a lot of anecdotal talk all the time when we talk about drug-related offenses. And people always say, you know, when the police come and they find a little bit of drugs on the premises, it's every man, woman, child, dog, and cat that gets taken down to the police station. Well, Madam President, that is what is going to happen here. Now, I make no complaints and I cast no aspersions on the TTPS, and I am not saying that they have abused these powers. But if you are creating a section such as this, we must consider, in the exercise as a responsible lawmakers, the balancing of rights. When you have a clause such as this, you want to consider how it will affect the person who might be innocently caught up in this. And when you talk about, you've created, via subsection 2, a mechanism for a person to prove their innocence, that they could not reasonably have known the intention of this item that was found in possession. And of course, possession has been interpreted over the years by the courts as possession and or control. Who has control of the premises? This is why you would find that, for example, a person who is the owner of property, but there's someone, an adult person living on the property who has narcotics in their possession, may be charged. And it's the same thing that would apply here. If someone is residing on your property and you have control of the property, that part of the premises, let's say an adult child who lives with you, has something in their possession, you can be deemed to be in possession and or control, and therefore you would be caught by the provisions of Section 10. So in law, in pieces of legislation that could have such far-reaching consequences to the liberty of persons, Madam President, it is important for us to look at this. When you create a defense, yes, it is an extremely challenging defense for someone to prove, but you must also look at the context of what we face today. The Attorney General is boasting about how fast trials are happening and so on, but just last year when we had, I think it was in the budget debate, the DPP talked about how many matters, indictments are waiting for more than 10 years to be tried. So a person who wants to prove his defense under subsection 10.2, he's looking at doing this 10 years down the road. So I strongly recommend that we consider reformulating clause 10 with respect to the reasonably ought to have known aspect of that offense, because you can be capturing a lot of persons with this clause, and it can be open to significant abuse by law enforcement if they so choose to do so in relation to persons who may be innocent and have to face a 10-year or 10 to 15-year wait before the court to prove that innocence. Madam President, let's move on. If I can move on to sections, clause 15. Well, the Attorney General has said that he will implement the consent. I'm happy to hear that in clause 15.3, because of course entry into premises, which are dwelling houses, you must have consent if you wish to go without a warrant. I would accept and welcome that amendment as well. Clause 16, Madam President. Now, the changes made to clause 16 essentially reduce the time frame that you can be held without a court order from 5 days, essentially, down to 3.5 days. Because prior, you could be detained for 72 hours, and then the police had 48 hours in order to go before the court and get the order that could detain you for up to 14 days. They have reduced the initial period of detention to 48 hours, but they have given the police the power to go within 36 hours to apply ex parte to a judge in the form set out. Now, Madam President, this is where I have an issue. I understand the adjustments to the time periods and the need to, as the Attorney General says, to surat the bill and to make it proportional. And so he's maintaining that it's now more proportional and so on with the reduction in the time frames. But Madam President, once we go into the realm of ex parte applications before the court, I do believe that there's an infringement of natural justice and the due process requirements under the law. You are essentially saying that the court can go before the police, the executive. That is what the police are. They are part of the executive. The executive is allowed to go before a judicial officer. Yes, they must go evidence on oath, but they must simply satisfy the judge that the further detention is justified and that the investigation is being conducted diligently and expeditiously, and they can get an order to hold you for up to 14 days. Madam President, when you say that something must be done or that the police officer may within 36 hours apply ex parte, really, I believe that you need some further protections in this section. And I believe that the court should have that a clause could be inserted here to say that the court can exercise the power to convert this initial hearing to an inter partes hearing, because that would preserve the right of the accused to come before the court immediately and say why their detention is not warranted. That way, you do not infringe the right to liberty without due process. You are not infringing upon the right to be heard, which is a fundamental aspect of due process and natural justice. Subclause 7 says that the person can make an application to a judge showing cause why the detention order should be discharged. Now, this reminds me of the cash retention orders made under POCA. We have similar provisions there, but there's an entire procedure. There's a form set out, I believe, under POCA, because I think some regulations were passed after litigation was commenced, to put it into the law that you ought to have a procedure by which someone can approach the court to have the cash retention order discharged. Madam President, I would strongly recommend we do the same thing here. The Attorney General has said that nothing prevents you going by way of habeas corpus to the court. Well, you've created a form that the police need only fill out and provide the evidence on oath and give it to the court in order to obtain this detention order. Respectfully, Attorney General, the same ease with which the police can obtain an order and sign off on a form that is detailed here in the second schedule to say, I swear to the best of my knowledge, information, that the contents are true, and simply state the grounds in this form, I think that there should be a form. There should be some sort of a form that an accused person should be allowed to fill out and go before the court and say, this order ought not to be discharged because, and be able to say the grounds. Now, a habeas corpus may achieve the same thing, but anybody who knows how these matters go and how they are dealt with, you're looking at time, you're looking at expense, you're looking at retaining an attorney. Do you think that somebody who you lock up for saying that you are a member of a gang knows what is a habeas corpus? He will have to get an attorney. He will have to give instructions. The attorney has to draft the documents. You have to file it in the High Court. Yes, habeas corpus matters are treated as a matter of urgency. But do not simplify the process for the police and for the executive to lock up people and detain them for 14 days. And at the same time say, well, you, Mr. Accused, who supposedly enjoys the presumption of innocence, you go the normal route of habeas corpus and find a lawyer and give instructions while you are locked up. So your access to an attorney really depends on whether the police want to give you or not. And listen, that's the reality. That is the reality. You see your attorney when the police let you see your attorney. You see your attorney when you know that you have a right to see an attorney and you ask for one. And that is the reality of the situation. So create processes that are easy for the accused persons to deal with in this law, Madam President, the same way. Madam President, as we move on to section Clause 17, one of my colleagues will deal with this in more detail, but I must say that proceeds of crime was really, proceeds of crime was passed with a special majority. So if you are importing a special majority clause, or a special majority provision to forfeit property from someone, I have serious concerns with the constitutional propriety of doing that by way of a simple majority clause. Because you have created offenses under this law that did not exist when proceeds of crime was passed. You have created offenses that carry, that a person can be convicted of under this law that did not exist when proceeds of crime was passed. There's a schedule of offenses in proceeds of crime, Madam President, and if the Attorney General watches the debates when those 2014 amendments would pass, he would see me sitting right there as a technocrat. So I'm very familiar with this. That schedule of offenses deal with categories of offenses. The categories of offenses were taken directly out of the Financial Action Task Force standards. We imported it wholesale as a second schedule into proceeds of crime, and it deals with categories of offenses. And the first one, interestingly, is organized crime. Now, at the time when we did that in 2014, yes, we had the anti-gang legislation. We had the law being operationalized. But, Madam President, I have a concern about whether or not there's legal certainty being created here in this procedure, in this by way of this introduction of poker into the anti-gang legislation. It is not enough, I believe, to say that we already have a regime for forfeiture of property, and therefore, by this law that creates new offenses, I can simply, by simple majority, move to forfeiture property. Madam President, may I inquire what time is my full speaking time?
You finish at 26 minutes past 12.
Thank you, Madam President. So I'll just move on now. So based on what I have highlighted here today, you know, the Attorney General raised other issues which would be addressed by my colleagues, but there are some very important things. When the opposition, and I must correct the record, when the opposition did not support the continuation of anti-gang legislation last year, we raised an issue about procurement. Madam President, the link between, and the Attorney General was at pains to say that they've introduced white-collar crime and they want to follow the money and Al Capone and all of this. Great. I like that. But when you do not have laws working in tandem together, he talked about the fact that the bail restriction and the anti-gang must work together. Well, what about procurement? Why don't we have a solid procurement act? Why is our procurement act not being implemented, but instead being whittled down every chance the government gets? Why don't we have proper procurement laws to prevent gangs from benefiting and profiting from state contracts? That is the question. If we want to talk about a meaningful approach to crime, Madam President, and I know my colleagues, we have a list of things that we can assist the government with if they don't understand how to really tackle the issue of gang violence in this country. Madam President, the DPP mentioned, again in his comments, how challenging it is when you're dealing with, because of the nature of the people you're dealing with, to acquire eyewitness evidence and things. You know what would help convict crime gang members? Working CCTV cameras. That is what would help. So when you come here to say that we need to have this piece of law is the only way, this is no silver bullet, Madam President, I maintain that I have serious concerns about the propriety of bringing this legislation by way of simple majority, because there are still, despite the adjustments made to poker, despite the adjustments made to the time frames for detention and so on, I think that the ex parte, and I've put forward some suggestions. I wish to put forward some further suggestions, and I will prepare a couple of suggested amendments, which I would have circulated shortly. But I do not wish to see a law as important as this, a law which has such far-reaching consequences, end up being challenged for a lack of constitutionality because it wasn't passed with a special majority. So I am urging the Attorney General to do the right and proper thing and put the special majority requirement back into this piece of legislation. No legislation that gives such draconian powers to the police to offend against the constitutional rights and freedoms, to whittle away those rights and freedoms in relation to persons who are suspected of offenses ought to be brought by way of simple majority. The second thing I would recommend, Madam President, is that a sunset clause be put back into this bill. Again, when you have laws such as these that are so draconian in nature, it is for a responsible parliament, a parliament to sit and examine the efficacy of the measures that it takes. Once you want to get into the realm of curtailing constitutional rights and freedoms, a responsible parliament ought really to come back and examine the efficacy of the legislation. And it is only, and that is what a sunset clause is there for. That is what a sunset clause is meant to do. We asked for the information last year. We asked for more evidence and more substantial proof that the law was working. It was not provided. And that is the single reason why we did not support it. But you have come back here now to basically say, well, we are going to pass it with or without you, and we are not going to bring it, back here for you to examine by any means whether it's working or not. Is that really taking a bipartisan approach and working with the opposition? It is not. You have found a way around us. You have come here and you have basically said, I really don't care for your support. Now, I don't understand why they laid this bill here with a simple majority and have gone out and said the population needs to pressure the opposition. Pressure the opposition for what? You obviously are not interested in some of our views. Otherwise, if you were interested in hearing what the opposition had to say and getting our buy-in into this bill, you would have kept it as a special majority piece of legislation. You would, which is, according to me, in my respectful view, constitutionally proper. And you would have also maintained the sunset clause because you give the opposition, the independent bench, everyone an opportunity to come back and examine the efficacy of the legislation. And finally, Madam President, I wish to propose that there's a regulation-making power introduced into this bill, and it is done by negative resolution. I firmly believe, again, that legislation that is so important, that can have far-reaching consequences when it comes to the liberty, security, the presumption of innocence, and all of these constitutional rights and freedoms that the citizens enjoy in this country, it ought not to take effect by the simple stroke of a pen of a minister, and it ought to be subject to the affirmative resolution of Parliament. If you wish to bring regulations regulations are meant to operationalize.
Senator Lachmidia, you have 5 more minutes.
Thank you, Madam President. Regulations are meant to operationalize laws. Nothing that operationalizes such a draconian piece of legislation ought to take effect because it is signed on the minister's desk and take immediate effect. It should be brought to the Parliament. It should be debated. And again, if the Attorney General is interested in hearing the views of the opposition in either house, really and truly, that is the proper way to bring regulations under this piece of legislation, Madam President. So those are the amendments that I would wish to propose. I would also say, and I would urge the government to not simply stand here and say that laws are necessary to effect change. Someone from the media asked me today, and they use a very interesting analogy. And they asked me whether or not, they said, whilst the opposition may have issues with the taking an AK-47 to kill a mosquito, but there's no bug spray, why not give the AK-47 to kill the mosquito? And I love that analogy because it raises 2 very interesting points. What happens when the AK-47 doesn't just hit the mosquito, but it hits everybody else that's around it? Do we have sufficient safeguards to prevent that from happening? And that is the question we must always ask ourselves. The second point I want to raise, and I know it will be raised later on by others, is why do we have no bug spray? Why is it that the Attorney General talks about the people, the processes, the plant and machinery, and then the law? But we are only hearing about the law. We have heard so many complaints about the resourcing. No piece of legislation will solve crime. Let me repeat it. No piece of legislation will solve crime if you cannot operationalize it. And to operationalize it, you need resources. You need resources, and the resources have to be placed in the right place, Madam President. So that is simply just an opening for what I hope to be a productive debate on the part of all members of this House to really come out of this exercise with a good, meaningful piece of legislation that could withstand judicial scrutiny and that would that would not only make an impact on crime, but will also protect the rights of innocent citizens and those who are supposed to enjoy the presumption of innocence, even if they are suspected of committing offenses. Thank you, Madam President.
Senator Richards.
Thank you, Madam President, for recognizing me and the opportunity to make a contribution to this debate today, which is the Anti-Gang Bill 2021. Let me at this time take the opportunity to wish a happy International Women's Day, although it was celebrated yesterday, to Trinidad, Tobago, and certainly the amazing women who formed this parliament in terms of your good self, Madam President, the members of Parliament, female, and of course the parliamentary staff who support us all the time. Again, we're here talking about anti-gang law in Trinidad Tobago, and let me say from the start, and it's always quite enjoyable to listen to Senator Lakshmi Dayal. I think she has a brilliant legal mind, and any republic like ours always needs strong opposition and independent voices to add to the debate to make what is supposed to be great law. From the start, I will suggest that I usually don't go first, but because I have the honor to sit as Vice Chair of the Joint Select Committee on National Security, and we are currently in the process of an inquiry into gang activity, I think I have quite a bit of contribution to make where this is concerned, and some of the data I'll present has already been broadcast in that forum, so I won't be breaching any regulations regarding divulging of information that comes to the committee. Let me say from the start, I think that it's untenable in 2021 that any country not have active anti-gang legislation, and I think we all agree with that. It is, given what any researcher will do in any jurisdiction around the world, we see the damage, the continued damage and mayhem that gangs, organized formally or informally, create in any society, and their significant contribution to criminal activity around the world. And Trinidad Tobago is certainly no different. And we've had quite a history of gang activity. In my opinion, we started to see gang activity flourish in Trinidad Tobago and proliferate in Trinidad Tobago in a real sense after the attempted insurrection in 1990 by the Jamaat al-Muslimin that went largely unpunished, and to me gave almost a pass to persons who feel, well, if you could hold up a parliament, shoot a prime minister, and get away with it, well, we might as well run amok, because there's no consequence to even the most serious. And that was a gang. Let's not kid ourselves. That was a gang. Came together to overthrow a country. And that went largely unpunished in Trinidad Tobago, or probably completely unpunished. As a matter of fact, some may suggest it went rewarded. And it was the genesis of what I see as a continuing escalation and coalescing of gang activity in Trinidad Tobago, so much so that fractions of that situation ended up holding this country at ransom in a fearful, significant way, in some instances extorting money from people for business protection, etc. So as I said before, I think it's, given the fact that it has escalated significantly, this country having no active gang legislation or law is unthinkable. What we are debating today, however, and I even believe that the opposition, to be fair, agrees with that. What is a debate today is the contents and provisions contained in the law that has been serving this country quite a number of years. Of course, the Sunset Clause came, and I agree with Senator Lakshmi Dayal that I do agree that this legislation should also have a Sunset Clause installed in it, through you, Madam Chair, to the Honourable Attorney General, so that, and I don't think it should be 3 years, I think it should be 5 years, so that the Parliament can examine this again in a fulsome way to ensure that it has fulfilled the mandate that it was intended. So I humbly suggest to you, Attorney General, that you consider including in this a 5-year sunset clause. So what is the intention of this law? It is intended to prevent, criminalize, discourage gang recruitment, involvement, and activity in Trinidad and Tobago, to criminalize the promotion of gang involvement and activity, or from persons criminally benefiting financially or otherwise from gang involvement and activities, and to protect the citizens of Trinidad and Tobago and our visitors. in doing research for this, when you go back, we made international headlines in 2011. And I'm quoting from the Guardian of the UK, an article written by Adam Gambat and the agencies, Thursday, 25th August 2011, and it is a timestamp of 10:37 Eastern Time, when I quote, "More than 100 people have been detained in Trinidad and Tobago after the country imposed a national state of emergency in response to a wave of violent crimes linked to drug trafficking. The Caribbean nation declared a limited state of emergency after 11 people were killed over the weekend, a move amid growing concern that drug gangs are using Trinidad as a transshipment point for South American cocaine heading to Europe and the US. Then Prime Minister Kamla Persad-Bissessar announced a 15-day state of emergency on Sunday, which included a 9 p.m. to 5 a.m. curfew in cities, towns, and granted police wider powers of arrest." The article went on later on to say Trinidad and Tobago's then foreign minister told the New York Times the move was a limited intervention to deal with gangs and to get guns off the streets, although he added the state of emergency could only be extended for another 90 days if granted approval by the Parliament. And the country's Attorney General at that time was, of course, Anand Logan. There are several articles in that vein around the world dealing with gangs. So we've had a long history of gangs in many instances attempting to destabilize this country, as I said before, from 1990. Then in 2011, most recently in June of last year, when the police killings triggered some protests in Port. But the police, sorry, let me rephrase that. The persons who died at the hands of police in Mova triggered some protests in Port of Spain, and the Minister of National Security and the Commissioner of Police both indicated that it seemed to have been organized in some way, and there may have been some gang activity involved where that is concerned. Madam President, I want to quote from a newspaper article. Anti-gang law defeated as opposition fails to support extension. It's a Friday, November 20th, and it's written by Jensen Levend. And for some reason, I'm not seeing the newspaper tag here. I'll have to give it to the Hansard people. And the title is, of course, Anti-Gang Defeated as Opposition Fails to Support Extension. And part of that quotes the Commissioner of Police and Baratara MP Saddam Hussein in the other place, saying the bill did not address or did nothing to address murders and the feeling of safety by residents. And part of that article also quotes the Commissioner of Police, Gary Griffith, speaking on CNC3's newscast on that Friday night, and said the law was responsible for the reduction in murders that year, and added that the only time the law was abused was following the introduction during the state of emergency in 2011, where over 200 people were arrested under the law, resulting in almost all being released without charge, and many suing and winning their court cases. At that time, interestingly enough, now Commissioner Griffith was then a national security advisor to the government. So the interesting thing about this is that one of the points of contention of many persons in the other place and earlier on today is about the effectiveness of the legislation. And if the legislation transgresses on constitutionality as to whether it should require a 3/5 majority, or is it a simple majority as proposed by the Attorney General. I am not legally trained, so I'm not going down that road at all. I can quite frankly tell you I'm not well trained enough to make that determination. But to me, even with that said, there is no logic in the assertion that, well, even if it is less effective than envisioned, and I agree that I would have liked, and I'll quote some statistics later on in my presentation, that I would have hoped it was more effective in terms of rounding up and detaining and charging gang members, given the number of gang members we hear existed. The Attorney General quoted from some information from the Commissioner of Police, and I'll also quote some additional information that was divulged and publicly broadcast in the Joint Select Committee 2 weeks ago. In 2018, there were 211 gangs with 2,400 gang members, and by 2020, that was down to 129, which is a 30% reduction, according to the Commissioner of Police. And which resulted in 1,114 gang members, down 58%. But the number of arrests, to me, still pales in comparison to what I would have liked to see, given the numbers of gang members and gangs that are touted to exist in Trinidad and Tobago. But you see, I'll make an analogy here, and the effectiveness of gang legislation is not only dependent on the legislation, and we have to realize that. What is important is, and I'll make an interesting analogy, and that it is not meant to trivialize the issue of crime in Trinidad and Tobago in any way. It's just an interesting analogy because I'm from broadcasting and it's part of what I know. You know, let's make an analogy of the criminal justice system like the music industry, where there are three central parts in the music business to create a hit song. The hit song in this instance, we're talking about effectiveness of gang legislation, anti-gang legislation. And I will tell you, if anyone does research, anti-gang law is extremely difficult to prosecute in any jurisdiction around the world. And that's because of how quickly gangs evolve and how much they change from time to time. Because as we are debating here, bet your bottom dollar gang leaders and gang members are listening. So they know what provisions we're trying to provide in law. They're not stupid. They know what the law is in many instances and how to try to thwart the law. So they go about and they change and evolve very quickly. So the three parts in the music business, by your leave, Madam President, that are analogous to the criminal justice system. First of all, if you want a hit song, you need a good songwriter, right? So you have to write a great song. We, the legislator, are the songwriters. We're writing the song. The singers are the DPP and the police, right? So you have a great singer and a great song, you possibly have a hit record. But there's another element that must be understood in this, and that's the criminal justice system, the judiciary. And if all three are not working in concert, if all three parts are not working effectively, then no matter how good we write law in this and the other place, if the other parts aren't working and applying the law effectively in terms of the DPP's office and the police, and Senator Lakshmi Dayal spoke about resourcing these agencies effectively so that they can work. But we also need to hold those agencies to account when they are resourced, including the judiciary. And I'll quote some data that really doesn't speak well of us as a country at all in terms of the other elements, inclusive of the legislature, working in tandem and in an integrated form to make sure that the law works. And this goes for any or all laws in Trinidad and Tobago. So it's not just, and I'm not diminishing the importance of passing good law and writing good law. But if you write and pass good law, it's also important for the DPP's office and the police and the judiciary to do their parts to effectively complete the circle or the cycle of effectiveness. So in 2019, Madam President, at the sitting of the Joint Select Committee National Security, it was revealed by the SSA, the Strategic Services Agency, that there were 8,154 illegal firearms circulating in Trinidad and Tobago. That's according to estimates. In 2017, they also spoke about gang prevalence. It was also revealed that at the number of 10,000 in 2019, number of 54 firearms and 18,000 bullets were seized by police, primarily at the hands of gang members. It was revealed that at that time, Trinidad and Tobago had 2,000 gangs, averaging 20 members per gang, giving a total of, if you do the calculation, simple math, 40,000 gangsters or gang members in the country. The Commissioner of Police more recently, about 3 weeks ago, at the publicly broadcast Joint Select Committee National Security, indicated now there are 134 gangs in Trinidad and Tobago, with a total of 1,056 members. Among the gangs he identified, which was already publicly broadcast, are Rasta City, Muslim Gang, 6th, and other smaller gangs such as, and get this name, ABG. And that's an acronym for Anybody Can Get In. Isn't that interesting? ABG, anybody can get in. And also he identified Mova and Maloney gangs. And that's very interesting because it kind of dovetails with the information presented by the Attorney General, who also said there were 28 22 gang members arrested, or 28 gang members arrested. Also in 2019, he said there were 5 gang-related murders and 13 arrests. And the Honorable Attorney General went on to give other statistics in terms of to identify what he may have been proffering as the effectiveness of the legislation. I'll say again, I don't think those numbers are impressive at all, given what was at stake. But I also know it's not only about the effectiveness of the law, it also speaks in some instances to the effectiveness of the police service in the application of the law. So we also need to keep that very much in mind. What is also interesting to me, and I think this is an interesting part of my presentation today, is the issue of this legislation aimed at dealing with gang membership and gang activity, but information also provided, and it's in the public domain, by the Trinidad Tobago Prison Service Administrative Department. I'll present now a breakdown of persons on remand and the impact of those persons on remand and their indoctrination into gang activity behind prison walls. So interestingly enough, and this is to me a dark smear on this country that continues to be unchecked and not dealt with effectively at all. So in remand in Trinidad and Tobago, in prison custody, and this has an impact on what I'm about to present in terms of the possibility of gang indoctrination in Trinidad and Tobago behind prison walls, while we seek to pass legislation primarily to deal with gang membership and recruitment outside prison walls. So persons awaiting trial 5 years or less, 606. Persons awaiting trial 6 to 10 years, 289. Persons awaiting trial in prison custody, since being committed to stand trial 11 to 15 years, 161. Persons awaiting to stand trial 16 to 20 years, 18. And persons awaiting to stand trial in prison custody more than 20 years, 6. 20 years, 6 persons. So, interesting, and the Trinidad Tobago Prison Service also notes that 60%, now this is a report from the prison servicer, 60% of the individuals entering the prison system will be inducted into a gang. Not may, will. 60%. So the longer you keep a person in prison on remand, the higher the possibility of them being indoctrinated in a gang. And we're seeking to pass law to deal with gangs primarily outside. So we have a prison system that seems to be a more effective contributor to gang activity than outside. That's a crying shame in this country. And it's because of the ineffective criminal justice system that has this extended 20 plus years, and I went through the breakdown earlier on, of persons awaiting trial that we don't seem to have any shame about in this country or seem to have any will to deal with effectively, because it's a constituent that, well, and I always say, remand means you have been charged but not yet found guilty. But it doesn't matter to Trinbagonians because, well, they have no right to get in there anyway. If you didn't do wrong, you wouldn't get in there. And the report goes on to state that individuals, if not already a member of a gang on entry, are easily influenced into joining a gang within the prison. And two of the main factors of being recruited into gangs in prison include time spent in prison custody and overcrowding. So we seem to be creating gang members effectively behind prison walls. And what are we doing about that? Is this legislation dealing with that? No, because we as a country are contributing to that because of our horrendous prison system. There are 1,861 men on remand awaiting trial in inhumane conditions at the behest of the judiciary because they're holding these individuals until they can get to trial. Madam President, through you, I want to make an interesting comparison with a very, very internationally known case, which was recently highlighted in a movie and a book called Guantanamo Diaries. It's a 2015 memoir written by Mohamedou Ould Salini, who was held in the US without charges for 14 years. He was one of the individuals picked up recently after 9/11 and suspected of being involved. It is the only case on record that the US has admitted to torturing a detainee or a prisoner. He spent 7 years to get to trial, was acquitted. The Barack Obama administration then appealed. It took him another 7 years and 2 months for him to be released. Most of our inmates in our prison in Trinidad and Tobago would jump at that opportunity to be out in 14 years because there's some in there more than 20 years. I think it's a crying shame. And while we're debating anti-gang legislation, attempting to give law enforcement tools to deal with gang involvement, our prison system is violating human rights.
Richards, I just want to give you a little guidance here. We have the bill before us. You've gone into some detail about gangs in general. You've spoken about the prison system, but I will ask you, as you continue to really get to the bill as well and link what you're saying to the bill, okay?
I'm guided. Thank you for the guidance. So I will go directly to the bill now. And I went through making some notes while the Honorable Attorney General was speaking. Some points I'd like him to, if possible, focus on. In Clause 3, the bill proposes to define certain key terms for the purpose of this legislation. A gang means a combination of two or more persons, whether formally or informally organized, who engage in gang-related activity. And one of the concerns I have with organized there is the fact that in the evolution of gangs around the world, and certainly in Trinidad and Tobago, in many instances, persons facilitate gang activity in a one-off because they know staying in a permanent arrangement as a gang member can prove to put them at a disadvantage and subject to detention, arrest, and charges. So gangs are not as formally organized as they would have been 5, 10, 15 years ago. They come together to perform a crime and they move aside. And in some instances, a person may facilitate by giving information, etc. So I don't know if we can amend that language where organized or add some kind of caveat to introduce a wider catchment, as it were. One of the other points of contention I have is in Clause 5, where it states a person who performs an act as a condition for membership as a gang. I would add, suggest respectfully, or knowingly facilitates gang activity or gang functions, because, as I said before, not many persons who, the way gangs have developed, not only in Trinidad and Tobago, but around the world. I'm waiting for the sound effect to pass. Do so in a formal, long-term manner anymore. They don't coalesce as gangs as we knew them 10, 15 years ago. They come together, do their deed, and move on. So I think, and in many cases, the involvement may be to give money to rent a car, to loan a gun, to give information, and then they're on their way and they're rewarded later on. So it's not as coalesced a gang arrangement as it would have been many years ago. So I think that needs to be tightened up based on the evolution of gangs. Also, Madam President, staying with Clause 5, and the part that says a person who is a member of law enforcement authority or a person involved in intelligence gathering who commits an offense under this clause on conviction or indictment to imprisonment for 25 years. I'm just wondering, I'm asking a question here. If this law enforcement authority includes the prison system, and I think I presume it does, but I'm hoping that can be clarified. Also, one of the clauses that I'm concerned with is Clause 11. And I think the Attorney General may have referenced it earlier on. It speaks to harboring a gang member on summary conviction to imprisonment for 10 years. It would be a defense if the person charged could prove that they had not have reasonably known that the person they were harboring was a gang leader or gang member. So to me, in terms of my understanding of natural justice, if you're accusing me, why am I the one to prove that I could have not have reasonably known. To me, you should provide evidence that you know I knew that I was harboring the person. So I think the Attorney General may have referenced that, but I'm not sure. I hope he can deal with it in his rounding up. In Part 3, under Clause 10, empowers a police officer in Part 15C, and I see a discrepancy here, although my colleague, Senator Vera, tried to explain it to me. But I still have a real concern with it. In B says to enter and search a dwelling house with a warrant issued by a magistrate where the magistrate is satisfied by evidence on oath that there is a reasonable ground for believing that a gang member, gang leader, or person with whom the magistrate has reasonable cause to believe has committed an offense under the Act may be found in the dwelling house. And Part C says to enter any other space or premises not used as a dwelling house, including a building, ship, vessel, carriage, box, or receptacle without a warrant. And I'm wondering why the difference in B with a warrant and the difference in C without a warrant, even if the law generally provides for the sanctity of a home. And I think what happens if the home is a business place, which happens very often in Trinidad and Tobago, and it falls between a combination of both categories. So I think that if the Honorable Attorney General can address that, right? In Clause 16.3, requires a police officer upon detaining a person must, without delay, inform the person of the grounds for his detention and record the grounds for his detention in the station diary. What's the recourse if this is not done? Which is very possible. They hold you, they grab you, they take you away. They don't feel to tell you what you're being detained for. And we have a recent case where it's an investigation, so I won't speak too much about it. You end up not breathing and your heart not beating. So, and I don't know what the recourse for if this is not done. Who does the detainee complain to? And what is the penalty if the officer does not subscribe to this? Clause 16, 4, provides that where a police officer has a reasonable grounds to believe it is necessary to detain a person beyond 48 hours detention period, and I agree with this because it's now been reduced from, I think, 72 hours to this. What I have heard over and over has happened, and I don't know what the cure for the mischief is that, okay, police officers know that if this is passed, you have 48 hours to detain a person, to obtain or secure or preserve evidence relating to an offense under the Act, to prevent interference with an investigation of an offense under this Act, or to prevent the commission of an offense. The officer may make an ex parte application for a detention order to a judge within 36 hours of the person's detention in the form set out in the second schedule. This application must be supported by evidence and oath. So, what has happened in the past, and I've heard countless people complain about this, criminal defense attorneys, is that, and I don't know what the cure is, quite frankly. So the officer holds you for 48 hours and then realizes he doesn't have the evidence, so he lets you go, and then he picks you back up in 12 hours and starts the process again. That happens in Trinidad and Tobago. And we have to make law understanding the context that we're living in. So this happens 3 or 4 times, and before you know it, the person is in, out, in, out, in, out. And the officer is well within the ambits of the provision, but they're using craft to deal with the situation as it were. And I don't know what the recourse that the detainee has. So to me, that needs to be dealt with more effectively. So while I agree with many of the provisions included in this, Madam President, and as I said at the start of my presentation, that I think it's unthinkable that any country, in particular Trinidad and Tobago, given what we've been dealing with over the last 15 or so years, and certainly since 1990, with the growth, proliferation, and damage that gangs have and continue to cause in Trinidad and Tobago, that we can continue to operate absent of anti-gang law. We need to tighten this. The Attorney General was quite charitable and said that he came to listen, and that suggests to me that he's open to amendments being put forward. in the interest of making what is good and effective law in a really difficult situation. And one of the issues that I hope we can also deal with is the issue of what has been described in the UK law and Australian law also as making a differentiation between gang activity and criminal enterprise facilitated by gangs. And that is sort of a merge between what we consider hardcore gang activity and its nexus between white-collar crime in Trinidad and Tobago. So, in principle, as I said before, I support this country's move to reinstating gang law as expeditiously as possible because of what's happening, and I would shudder to think that we would continue into the future without laws to deal with gangs in this country moving forward for the next 2, 3, 4 years, because that is going to be extremely problematic. All it's going to do is give the gangs a sense of, well, there are other laws that may be applied to them, but no specific laws related to being involved in a gang, recruiting a gang, and in particular, recruiting young persons in gangs, because the recruitment age for gangs in Trinidad and Tobago is between 11 and 14 years primarily, very often in schools. So with those few words, Madam President, I thank you, and I hope we can continue to have fervent debate on this in the interest of making anti-gang law that is passed and that can protect the people of Trinidad and Tobago and our visitors. I thank you.
Honourable Senators, at this stage, the sitting will be suspended and will be resumed at 1:30 p.m.